A unilateral mistake is a mistake one contracting party makes regarding the contract's terms or subject matter. In Monarch Marking System versus Reed's Photo Mart, we explore whether a unilaterally mistaken party is entitled to rescission. Monarch Marking System sold labels. Reed's Photo Mart wanted to buy 5 different types of labels from Monarch. Alan Tromer, Reed's vice president, filled out a purchase order for the labels. For the first 4 types of labels, Tromer indicated that Reed's wanted to buy a quantity of, quote, 2M, unquote. For the 5th type of label, Tromer indicated that Reed's wanted to buy a quantity of, quote, 4mm, unquote. Monarch understood the phrase 4mm to refer to 4 million. Accordingly, Monarch printed and shipped 4 million of the 5th type of label to Reed's. Upon receiving the shipment, Reed's rejected it and advised Monarch that there'd been a serious mistake. Monarch sued Reed's in Texas state court to recover the price of the 4 million labels. Reed's asked the court to rescind the contract because it was the result of a mistake. At trial, Monarch introduced evidence that pursuant to custom and usage in the label industry, the phrase MM means 1 million. The jury accepted Monarch's argument that MM means 1 million. The jury rejected Reed's claim that Monarch knew the amount was a mistake. The trial court entered judgment on the jury's verdict and awarded Monarch the reasonable value of the labels plus attorney's fees. The Texas Court of Civil Appeals reversed and remanded for a new trial. In so doing, the appellate court found that the trial court should have submitted an issue to the jury regarding whether Monarch should have known that the 4mm order amount was a mistake. Monarch appealed to the Texas Supreme Court. There, Monarch argued that rescission isn't available in the case of a unilateral mistake unless the non-mistaken party can be returned to the position it was in prior to the transaction. Monarch further argued that rescission wasn't available in this case because Reed's made a unilateral mistake and Monarch couldn't be returned to the pre-contractual status quo. Accordingly, Monarch asserted that the trial court's alleged failure to submit an issue to the jury regarding whether Monarch should have known about Reed's mistake was irrelevant.